Florida is one of the largest rental markets in the entire country, and its habitability laws reflect the unique challenges of managing property in the Sunshine State. If you're a landlord in Florida, your primary reference is the Florida Residential Landlord and Tenant Act, found in Florida Statutes Chapter 83, Part 2. This statute governs virtually all residential rental agreements in the state. Under Section 83.51, Florida landlords have specific obligations. You must comply with all applicable building, housing, and health codes. You must maintain the roof, windows, doors, floors, steps, porches, exterior walls, foundations, and all other structural components in good repair and capable of resisting normal forces and loads. You must maintain plumbing in reasonable working condition, provide running water and hot water, maintain heating and air conditioning systems where provided, provide working smoke detectors, maintain pest control, and, in Florida, this one is a big deal, provide trash receptacles and arrange for removal for buildings with 4 or more units, and keep common areas in a clean and safe condition. Let's talk about what makes Florida different from most other states. The climate here creates habitability issues that landlords in northern states simply don't face. Air conditioning is not a luxury in Florida. When summer temperatures exceed 95 degrees with near total humidity, a broken AC unit is a genuine health emergency, particularly for elderly tenants or those with medical conditions. Florida courts treat cooling system failures with the same seriousness that northern courts treat heating failures in winter. Mold is arguably the single biggest habitability concern in Florida. The combination of heat, humidity, frequent rain, and the prevalence of enclosed, air-conditioned spaces creates a perfect environment for mold growth. Landlords who don't proactively manage moisture intrusion, ventilation, and AC maintenance will inevitably face mold complaints. And while Florida doesn't have a specific mold statute, courts have consistently held that significant mold contamination constitutes a habitability violation under the general standard. Pest control in Florida is another critical issue. The state's warm climate supports year-round insect activity. Cockroaches, termites, ants, and mosquitoes are constant concerns. For buildings with 4 or more units, the landlord is responsible for pest control under Section 83.51. For single-family homes and duplexes, the lease typically determines who is responsible. But regardless of what the lease says, a severe infestation that renders the property uninhabitable falls back on the landlord under the warranty of habitability. Florida also faces unique challenges from hurricanes and tropical storms. While the landlord isn't expected to prevent hurricane damage, the obligation to maintain the property in a condition that can resist normal forces and loads means that landlords must keep the structure sound, replace damaged roofing and windows promptly after storms, and address water intrusion that often follows severe weather events. Post-hurricane habitability issues have generated significant litigation in Florida, particularly after major storms like Hurricane Irma and Hurricane Ian. Florida's tenant remedy process is structured and specific. Under Section 83.60, if the landlord fails to maintain the property, the tenant must deliver written notice to the landlord specifying the nature of the non-compliance. The landlord then has 7 days to make the repair. If the landlord fails to act within that 7-day window, the tenant can terminate the rental agreement or, in some cases, withhold rent. Florida does allow rent withholding, but the process is specific. The tenant must give proper 7-day notice, and the non-compliance must materially affect health and safety. If those conditions are met and the landlord doesn't act, the tenant can withhold rent. However, if the landlord disputes the claim and files for eviction, the tenant must deposit the withheld rent into the court registry. The court then determines whether the withholding was justified. Florida does not have a statutory repair and deduct remedy. Tenants cannot make repairs and deduct the cost from rent. That option simply doesn't exist under Florida law. This is a significant distinction that gives Florida landlords more control over the repair process. One important nuance in Florida: The statute distinguishes between the obligations for different types of properties. For single-family homes and duplexes, the landlord's duty to comply with building codes can be modified by the lease if the tenant agrees in writing to take on certain maintenance responsibilities. For multi-unit buildings, the landlord's obligations under Section 83.51 are more rigid and cannot be easily shifted to the tenant. Florida's local jurisdictions add another layer. Miami-Dade County has its own housing code and an aggressive code enforcement division. Broward County, Orange County, Hillsborough County, and other major markets have their own local ordinances and inspection programs. Some Florida municipalities require rental licenses or certificates of occupancy that must be renewed periodically, tying landlord compliance to their ability to legally rent the property. Florida's anti-retaliation protections are found in Section 83.64. Landlords cannot increase rent, decrease services, or file for eviction in retaliation for a tenant exercising their legal rights under the Landlord-Tenant Act. This includes making repair requests, filing complaints with government agencies, or participating in tenants' organizations. The burden is on the tenant to prove retaliation, but if established, the landlord can be liable for damages. For the complete guide to Florida habitability laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel so you never miss a state in our series.